All right, welcome back. Our next panel is called Global Incident Response, Managing Incidents Impacting Global Enterprises. Very interesting panel. Our moderator is Cedric Burton. He's a partner at Wilson Sonsini. He is based in Brussels, and he co-chairs the firm's global privacy and cybersecurity practice and is the managing partner of the firm's Brussels office. And he also leads the EU data regulatory practice. Cedric, thanks for moderating. Welcome.
Thank you, Burton.
Very pleased to be joined today by Nicola Kerr-Shaw. She's counsel at Skadden in the firm's cybersecurity and data privacy practice group and the artificial intelligence practice group. Nicola is based in London. She's joining us today from Madrid. She previously worked at a major worldwide financial institution where she built global legal governance structures for cybersecurity, privacy, data, AI, and led cyber incident responses. Welcome, Nicola. Very pleased to be joined today by Tim Jones. He's a partner at Norton Rose Fulbright, and he's based in London. Tim's in the global data protection, privacy, and cybersecurity practice, and he advises on the full life cycle of cybersecurity incidents. Welcome, Tim. Thanks for joining us.
Thanks, Bruce.
And finally, pleased to welcome back Sean Hoar. He is partner and chair of the national cyber team at Constangy, Brooks, Smith, and Prophete. He's based in Portland, Oregon. Sean previously served as the computer hacking and intellectual property lawyer, or the CHIP, for the U.S. Attorney's Office in Oregon. Sean, it's great to see you again. Welcome.
Thanks, Bruce. Appreciate it.
Cedric, let me turn it over to you.
Thank you, Bruce. Good morning, good afternoon, everybody. Thanks for joining us today for what promises to be a compelling discussion on global incident response and its legal challenges. As we know, the rise in frequency and sophistication of cyber incident poses significant risk to global companies. These incidents can quickly escalate into complex multi-J situations where legal, regulatory, and geopolitical factors will intersect and demand swift and coordinated response. And that's what we're going to explore today, is how global organizations can navigate this changing landscape. So we'll not only cover the immediate steps for managing a cyber incident, which has a global impact, but we will also look at how to build a resilient response framework that can evolve in light of the global challenges faced by companies. With this high stakes, global company needs to prepare for various scenarios. It goes from handling regulatory expectation in different jurisdictions worldwide to dealing with incidents influenced by geopolitical factors, which are getting trickier and trickier. And this often requires balancing rapid response effort with compliance across diverse and conflicting legal requirements worldwide. For that purpose, we go in 4 steps. 1, we're going to look at how to design a framework. 2, we're going to look at the legal changes and the legal requirements. 3, we're going to focus on the communication and collaboration, communication with the public and collaboration with law enforcement. And then we try to look at what could be the future in that field and what are the ongoing trends. But let's now get started. I'm very pleased to be joined by this amazing group of speakers. And I would ask you, Sean, to start with, to give us some hints on how you can design an incident response framework that covers global and sometimes conflicting legal requirements. What are your tips? What would you do there?
Sure, sounds good. But first, it's really important to identify an established framework that aligns with the enterprise business model, their digital infrastructure, and then their regulatory obligations. And the frameworks may include, there are 7 or 8 recognized internationally and are appropriate based on what geographic needs there might be. But they include ISO 27035, this cybersecurity framework, the European Union Agency for Cybersecurity, or NISA, the first CSIRT framework, or if you're a global retailer and you process payment cards as a major part of your business model, it's the Payment Card Industry or Data Security Standard, or the PCI DSS. But ultimately, the framework needs to help the enterprise to systematically prepare, detect, analyze, and mitigate the incidents to reduce their recovery time, minimize any overall business impact, for them to gain visibility across the incident life cycle so you actually know kind of where you are, where you need to go, and identify the tasks to help you get there, and then to really continuously improve your response capabilities. And so any of those frameworks, and there are a couple others, will typically help guide that process. I personally prefer the NIST cybersecurity framework, and we usually map our incident response plans to the NIST special publication 861. I'm kind of a nerd that way, but the framework should ultimately encourage the enterprise to identify the scope of the incident. And what I mean by that is I've worked with a number of information security professionals over the years, and many of them, rightfully so, are really focused on the operational data that might be affected in the incident. What we really need to do, especially now in the time of increased privacy legislation, really look at also the sensitive regulated data that might be affected in an incident, and the scope should incorporate both, as well as third-party supply chain issues. And as part of that process, the incident response plan, as you build it out, should also identify the key internal, all the cross-functional incident responders, your marketing communications, your risk compliance, your financial folks, as well as the typical information technology responders, as well as your external responders. Identify the tasks that need to be addressed at every phase of that incident cycle. And when you look at any one of these frameworks, they've typically identified the major tasks that are likely to occur, and you can identify that, work that into your plan, and then identify the different protocols you should follow at different decision points. Like if it's a ransomware matter, for instance, you may have a decision tree about whether you pay or not pay a ransom. Draft whole need statements. If there are things that you know you're likely going to need, go ahead and do that ahead of time outside the nature of the crisis, like statements for your internal employees, statements for important third-party clients, and then, of course, you customize it. But the bottom line is that you have to ensure it covers your global requirements. And so it's really essential to identify all your industry, your regulatory, and your contractual obligations, and then identify how to comply with them, and maybe put those in an appendix or appendices, so that in a crisis moment where you've got 43 other moving parts, you can actually use your incident response plan to guide you through those and track, for instance, the timing of notification, the means of notification, and make sure you've documented that it's ultimately completed. And if you're an incident commander and you're working with 17 other people, others may own certain parts of those responsibilities, but using that incident response checklist, we're able to make sure that everything gets assigned properly and completed properly. And ultimately, it ends and begins with preparation.
Yeah, that's great to hear. I mean, you mentioned the NIST framework as like your preference. Can you elaborate on that? Just like in 10 words, why is it your preference? Why is the NIST framework like the one you prefer?
I've always found it's much easier to understand, and so I tend to work with information security or technology professionals from very small businesses to very, very large, what we call the Fortune 100 businesses or so, and you see a wide chasm of experience and credentials within that. And so even the less experienced information technology professional, if they read the words of the NIST framework, my experience is that they typically can better understand that sometimes in other frameworks. At least that's my personal experience.
Interesting. Okay, great. Thank you. Let's move now to the legal challenges, and Nicola, maybe you can answer this question. So when there is a global cyber incident that affect multi-jurisdiction, which is frankly nearly always the case, and that you face very legal obligation, how do you prioritize response action? With that?
It's a great question. I've obviously spent, as in my introduction, significant amount of time in-house. And I understand that when an incident hits, business is key. And that's what the business wants to focus on. They want to get the business up and running. And there's a lot of pressure around that. And then but there's lots of other actions that can be taken to really reduce legal risk and that are really important. So I think going to what Sean was just saying, preparation is key. So knowing in advance, who you have to notify, what are the thresholds to notify, who has the decision to notify, if it is just notification, considering things like privilege, which is such an important tool that as lawyers we have in relation to managing legal risk while maintaining business continuity, going, right back to the question. Obviously, when you're in the middle of an incident, all you want to do is get the business up and running again and it to be over. But often we're seeing now more and more litigation post-incident. So really important to kind of be aware of all of this. And as part of that is being aware in the preparation. Many incidents I've advised on when, there is a big difference between clients that have had lots of practice, done tabletops, training, understand their needs. They know who has to be in the room. They know who has authority to make decisions. And so practicing that, I think, is key. You don't run a marathon without going for a run. And it's the same thing with incident response and particularly practicing how to prioritize different response actions, who takes leadership for what, having breakout rooms and delegating authority to allow people to work on different things. Because much as, particularly some management want to be all over everything, that's not possible in those kind of first 24, 48, 72 hours when, what you do is key. And I think if you're jumping to the actual incident itself, what we always advise clients, obviously perhaps in making a decision on how you prioritize, maybe instruct external counsel, get some help, but take a breath, because not every incident, it sounds awful, all of them always start with panic and worry, but they don't all have to be a catastrophe. And be conscious of that. Often we want to communicate, and we can talk more about that later on, but be conscious of all communications and how those communications fit together, what you're saying, and whether you really need to communicate at that time. Just slow it down. And I think that's really important to then really consider what's the priority, get the business up and running. Don't forget the other notifications and legal obligations you have. But ultimately, it doesn't have to be a catastrophe.
Yeah, I think that's actually right. I mean, take a break and, see what's happening and stay calm. Tim, do you have anything to add to what Nicola just said?
Yeah, just to really echo what Nicola said, I think the question really depends on what type of incident we're talking about, but also where your client's real exposure is. But to start with, I think you need to ensure that you are coordinated as possible, especially when it comes to global incidents. And from there, you can prioritize certain actions. But if you don't have a coordinated approach, work streams can very quickly become pretty disorganized or ineffective. So one example is obviously a joined up containment and recovery plan across all regions. This can really have an impact on your path to green and subsequent work streams. But, if you've got one jurisdiction that jumps the gun, gets a local recovery team in, start initiating a password reset, that can really unwind a lot of the progress that you're making. A little bit like the same with comms. You can have a brilliant comms plan, but if certain jurisdictions aren't sticking to that or have gone out to regulators, the public, that can really, really increase the legal risk. So I think it's mainly about, understanding where the pain points are, where your exposure is. Ransomware obviously adds real complexity to that. Services might be down, SLAs may be breached, and, you might have competing interests from the regulators. We see in the UK, for example, having to report to the FCA in the wake of a cybersecurity incident kind of every 2 hours. We could also see a lot of CISO teams from clients demanding answers, demanding status updates and calls. And as Nicola said, you got to think about the art of the possible there. But ultimately, what's the real risk here? Do your clients or counterparties just want information, or is there a risk of cross-contamination? Do you need to get IOCs over to them as soon as possible for them to reconnect to your client's business? How does that contrast to the need to identify the impacted personal data? Can that wait a little bit? So I think you've got to really flex to the incident, make sure you've got a coordinated approach, and really from the outset, identify short, medium, long-term needs and risks, and ensure that the response is coordinated for one central group with the right stakeholders.
Yeah, thank you. And, thinking of global incidents, instinctively, I think of global political issue or geopolitical issues which come up, and especially in the current global context where geopolitics is out there and there's a lot of tension. How do you take this into account? In particular, if you have like a state-sponsored attack, how do you avoid geopolitical tension, legal and diplomatic issues, and the like? And can you talk a bit about that?
Yeah, so I think it's really important to note from the outset that state-sponsored attacks include a whole spectrum of threat actors, right, with different interests and goals, from destructive attacks to espionage. And I think state-sponsored attacks really do require different handling from all angles: comms, forensics, regulatory. These threat actors are far more sophisticated quite often. They have a much longer dwell time, advanced techniques for living off the land, novel persistence mechanisms. We've had a few clients that have performed reputable environment-wide compromise assessments and not found a nation state when they were in their systems. So I think what you need to do is first lean on government agencies. They're really important partners generally, but more so, I'd say, when it comes to state-sponsored attacks, for the additional intel they'll give, the additional assistance, but also aerial cover when dealing with other regulators, and they're probably the best place to advise on diplomatic issues. Secondly, though, I'd say that the importance of attribution. State-sponsored actors don't tend to identify themselves in the same way as criminal gangs. So there has to be real analysis of the IOCs and the TTPs, some of which may have never been seen before. You need to get an opinion from a forensic team. Sometimes even the most reputable forensic teams haven't come across these TAs, though. So, sometimes you'll need more than one opinion. For one incident, I can remember we actually got 4 different opinions. And I think attribution really goes to how you contain, remediate, find persistent mechanisms, backdoors, but also understanding their modus operandi and how that might feed into a risk of harm analysis. But I think the last thing I'd say is you've got to also think about down the line how you might justify your technical and organizational measures, for example, in the EU, UK, to a regulator or in subsequent litigation in light of who you're dealing with, and any causation arguments that you might run. So, even if we had appropriate technical organizational measures, which we say we did, this threat actor is so formidable that they have been able to circumvent them. So there's a real strategy when it comes to state actors. And I think you've also got to realize that geopolitical tensions are running high, and you need to be wary about retaliation and ultimately what you relay in public. But those are the main things I'd probably flag.
Yeah, thank you. I think I would just add that there are like national security consideration, which comes on top of that. Talking about geopolitical tension, you of course have national security issues coming up. Sean, maybe you can comment on this.
Sure. In terms of looking at the national security interests that may be affected and what you need to do to prepare for that, it really depends on what the national security interest might be affected, because the national security interest is really critical to how the enterprise responds. As an example, for instance, in the United States, organizations are currently being identified as whether they're part of our critical infrastructure due to a new regulation that's in the process of being implemented called the Cyber Incident Reporting for Critical Infrastructure Act of 2022. And it's gone through the regulation posting, that sort of thing. And now if you're identified as part of the critical infrastructure, all of a sudden you probably have a more urgent need to harden your defenses, for instance. You also have new reporting requirements. You've got to prepare for that to make sure that if your sensitive data or operations are affected due to unauthorized activity, you're going to have some reporting to do, and you're going to have to do a lot of remediation. And so depending on the nature of the national security interest of the enterprise, there should likely be now a kind of an ongoing and continuous enterprise security risk assessment. It's not just an annual, but it's continuous, essentially to defend against malicious trends, but also, as Tim was talking about, the specific nation state actors. Typically, the review is going to include an assessment to determine, first of all, whether any security controls can or should be enhanced. And in part, you're looking at the malicious trends or the specific nation state actors that might be affecting your national security interest, if you will. If you know they're currently coming into certain perimeter devices, you're going to lock those down. If you know it's going to be more social engineering, you're going to heighten that training with your employees. But the bottom line is you're going to look at that, the threat actors associated with that interest, and then refine your response to that. The enterprise could also be developing relationships with the government entity responsible for the national security interest and confirm the appropriate means and times for reporting. And you don't have to wait for a crisis to that occur. I mean, what I find is that representatives of those agencies, whether they be domestic or international, typically would like an opportunity to come meet you if you're part of a large corporate team or maybe part of an association. They would like to get to know who you are so they can actually better work with you in the event of a crisis or help harden your own targets with some of the tools they have. And so, and then typically if something does happen, it's a little easier if they knock on your door and you have the conversation because you're familiar with them and you know that they oftentimes have interests that are aligned with yours.
No, thank you. It's quite interesting to see that there's a convergence there. The framework you described in the US, we do have an IS2 in Europe. Actually, it's entering into force, or fully applicable as of tomorrow. As tomorrow is NIS2 day. But that's interesting that these frameworks are converging. At the same time, I do think there are a lot of conflicting compliance requirements out there, and the devil is in the detail as always. Nicola, maybe you can talk a bit about how you, practically speaking, handle sometimes conflicting compliance requirements when you deal with cyber incidents.
Yeah, I mean, absolutely. And sometimes I think it can almost seem overwhelming, different triggers, different regulators, especially with what's happening in Europe at the moment with NIS2 and DORA and some companies being subject to both and different regulators. And then you've also got GDPR, and they might also be in the UK and the US. So I obviously it can, I think, seem sometimes overwhelming. Often advice we would say again is that take a step back. If you can prepare, like have it all charted out so you know what the triggers are. or obviously your external counsel will know that already. I think the really important thing is to understand the relationship with the regulator. Tim was mentioning before that, updating the FCA every 2 hours, and the FCA has that very close contact with its regulated entities. It does expect full transparency. And I don't think it would necessarily be an argument in the UK to say, oh, well, the notification obligations weren't technically triggered to you, particularly in the UK when you might have notified in a different country. And I think that applies across the different regulators. So it's understanding that regulator, but understanding that the regulators also talk to each other, and you don't necessarily want them to hear about your incident from another regulator. So yes, it's important to map out, your strict triggers and your compliance requirements, so you don't, not hit the bar that they have set. But it's also, and you don't want to over-report either, but I think it's also really important to consider those expectations and those relationships between the different regulators to make sure that you are keeping them updated at the same time. And that's very important, not only cross-jurisdiction, but also cross-regulators. So, if you're notifying the FCA, should you be notifying the ICO and vice versa? Because there is an MOU in place. And I think it is that's really important in terms of that strategic approach. So, I think it's again, and the advice we give to clients is obviously with, NIS and DORA coming in with the 24-hour notification obligation. Sometimes it's okay to just notify with very basic information. I don't know the full extent of this yet. This is what we're doing. And just putting that holding statement in and then taking the time, because a number of times we've been instructed on incidents where the initial notification or communication has gone and it really doesn't describe the incident very accurately, or the incident's just evolved and they didn't really know the facts of the incident at that time. But just because there's a deadline and there was stress, they wanted to put something in. I think it's fine. My experience with regulators is have that transparency. They understand these incidents, and obviously an incident can be also is a very wide term, but often incidents are very complicated. They do evolve over time. Facts evolve, understandings evolve. Number of times I've jumped on a call and they've said, oh, everything I told you last time, just forget, it's completely different. We now understand this, and you start again. And that's okay with regulators too. So take the time you have. When you haven't got much time, with things like the 24-hour notification periods, it's just giving them an update and then bearing in mind, okay, I've notified this regulator under this too. What other regulators should I potentially also now just be giving a heads up to, even if that requirement's not strictly triggered, but I just don't want them to be finding out from another way or from the press, for example, a different source.
Yeah, thank you. Tim, do you have anything to add to this?
Yeah, no, I think just on that point, to the point of collaboration between regulators, I think from the client's perspective, it's really key to have that global notification strategy. I can remember a couple of clients that we helped off the back of the Move It incident. We had to make something like 50, 60 notifications. There are obviously going to be unique local requirements, but you need to agree on an approach across the board from the outset. So where are we landing on the high risk of harm, taking into account all the contextual factors? How does that translate to legislation in other jurisdictions? Because, it really doesn't help for a couple of outliers to go off and, as Nicola said, make notifications with barely any information, but you want to be seen to be really helpful. So you're almost putting in a lot of speculation and opinion, and that's just not really going to help you down the line. I think I'd also flag that, it's not just kind of US EU tension in terms of requirements, but even within the EU now, you've got DPAs interpreting and enforcing the exact same piece of legislation differently. In some EU member states, I won't name any, but some regulators, some DPAs think that just a compromised name and address necessitates an Article 34 notifications, whereas others have a much higher threshold before they even ask you to make any formal recommendation to notify. And that really brings tension for a client, because they go, well, why is that the case and what should we do? So I think, as Nicola said, take a step back and also look at what this looks like across the board, and come up with a strategy for the client, especially with these really global incidents.
Thank you, Tim. And I'm checking the questions from the chat, and there is one interesting question which I'm going to ask you, which is, in the event of an incident, across a large number of jurisdictions, you need to notify various authorities, including data protection, possibly do that over a long period of time due to, for example, late notification. The question is, how can you ensure consistency, given the complexity and time pressure? I think that's exactly what you touch on, but like, do you have any concrete tips or advice here?
Well, I think it's really important to have that central decision-making body and have that one source of truth, right? So you're all working off the same template. A lot of these notifications, they're asking the exact same questions in various different ways. There are some nuances, but ultimately, if you start with just one and then you amend from that, that's far easier than each individual office jurisdiction going, oh, this is how I draft it and this is how I draft it, because I'd probably say that ensuring consistency is far more important than style. Do you see what I mean? So that's what I'd say. And I think that goes to a wider piece of every single day, updating what that single source of the truth is and making sure that no one who's communicating externally, whether that's to a regulator or to customers or to the public, deviates from that without it going past that central decision-making body that has the most up-to-date information.
Yeah, so a good SOT is key here. Okay, thank you. Let's move on to the next topic, which is communication to the public, regulators, customer, and collaboration with law enforcement and regulators. So Nicola, maybe you can tell us a bit about how you look at communication strategies and what are the key legal considerations that guide how you handle that with your clients.
Yeah, absolutely. So obviously we've talked about preparation, and it's great when, if you're on an incident with the client and they've got a communications playbook. I mean, every communication playbook I've ever worked with has to be amended for the incident. And we've said incidents can be wide ranging, but just to have the basic groups of the people you need to communicate to mapped out, having basic terminology, how you like to, do you call people employees or staff, or, just how you like to approach things is great. And to have that kind of style. And is it an email? Is it a website? How do people like to do things? It gets changed. Every single one gets changed. And you're not trying to map out a communications playbook for every single incident or scenario, but it's just trying to have some basics there. But then after that, and the other thing I always want to point out as well is a lot of people talk about communications to regulators, customers, the public, and they forget staff. And the reason I really like a comms playbook is because it will remind you need to communicate with your staff. Even if that's to say to your staff, something's happening, do not communicate on it. Do not go onto social media. Do not speculate. You've got a blank screen, but we'll be in touch. We're handling this. That's a really important communication, and particularly if they're then customer facing or, in sales. So I think it's just reminding that sometimes I think, in incidents, it's almost like, oh, let's not say anything at all. But that is communicating something and not saying something. So, you want to reassure, particularly your staff, that you've got it all in hand. But just in terms of like legal considerations, I think it goes back to exactly what we've just been saying, and Tim was saying in relation to that response. It needs to be coordinated. You can't be giving different people different messages. And that can be stressful. It's the same, how do you do if you've got multiple notifications in multiple jurisdictions with multiple regulators? But also that all of those notifications also have to be coordinated with your communications. You have to be given that central, that golden source message has to be online. And it's the same tip, every time I work on incident, every day there's a new communications playbook or FAQs or whatever it might be, golden source, that is updated every day. Everybody has to get it from the golden source every day. And that is then centrally updated. It needs to be factual. You don't want to be facing liability later on for blaming someone or mentioning something that you shouldn't have done. Consider what you actually know. I mean, we've talked about this in kind of almost over notifying or saying things you don't actually know, like stress test. The number of incidents, again, that I've been on where they've said 100% it's this. And then when you really, as legal counsel, stress test that and say, do you mean that? Do you mean exfiltrated? Do you mean accessed? You don't know that yet. So, consider that within your communication as well. And think about wording carefully, because I've also been brought in on incidents where, the original notification's been sent and it's sort of said it's their incident, where I've faced a cybersecurity incident. We've unfortunately faced one, and actually it's a vendor's incident. but there's actions being taken with people potentially with API connections or other other links to the company proactively because of what they've heard in that statement. So think about that wording carefully in terms of what you actually know, but in terms of how you're stating it. And then it's the same thing. I've said it in two other questions, so I might as well say it again. But take a breath, step back. When do you need to communicate? Think about it. Don't rush into that communication. Obviously, I've just said don't forget stuff and don't not communicate if you need to. Sometimes you absolutely need to communicate, but don't over communicate either, because it can just look panicked and worried. And take that time. Even on GDPR, notification obligations, Article 34, you have got time if you need to reflect and really understand what's happening. So ultimately, be factual, be consistent, consider your wording carefully, go to a golden source, but take a breath and really think about what message are you trying to portray. Is it a legal requirement to do this, or are you just wanting to communicate?
Thank you. I think you raised like a very good point about communication with the staff, especially when you deal with, a multinational company with like thousands of employees and stuff located worldwide. Like communicating to them and trying to keep control on the communication is key. Now, the classic example is that usually if you get a ransomware attack, you have all communication means down. So, that means that you need to prepare for that and have like alternative communication means available to be able to reach out to your folks and keep that under control. Tim, is there any other point you'd like to make on the communication strategies?
I think it's pretty much been covered. I mean, it's just that transparency balanced against exposure, right? And as we've discussed, the facts are always changing, and having to backtrack or change the narrative can really result in a loss of trust and confidence that the incident is being properly managed. But I do think that it is important to be transparent, for example, in a ransomware situation, to call it ransomware, particularly if there is an ongoing risk to clients. I think that's really important. But I think it's helpful to set expectations in terms of providing updates. What we tend to say is, say when you are going to next provide an update. Don't just say, we don't know anything and wait for them to come back an hour, a day later. Well, is there an update? Is there an update? So we will provide an update in a day's time, 2 days' time, a week's time. I think it's also worth mentioning that, you have to ensure that privileged information is not inadvertently waived, and need to consider privilege on a jurisdiction by jurisdiction basis. And then there can be practical things like agreed FAQs and scripts are quite important, particularly if you've got, which you try to avoid, but sometimes there are multiple individuals in the organization that need to relay details of the incident. This is sometimes unavoidable if, for example, you have hundreds of clients that are impacted, as in 100 of your clients' customers, corporate customers, and this needs to be done through a relationship or a commercial manager. I think that's when you can really start to lose control of narrative. So make sure you equip them with what they need really to be confident they can have that conversation, but also be confident to say, I don't have the answers to any of your further questions, I'll revert. And I think the last thing, we obviously mentioned DORA and NIST too, maybe not as much as some of the other sessions today, but I think the way in which clients respond to incidents and their understanding of their response plans could really come under scrutiny. We don't know what that might look like, but it can't just be a simple case of offloading it to the lawyers. It seems as though managers, GCs will really be expected to know and be able to have a plan in place and to be able to understand all of those measures that Sean was talking about and all of those certification requirements and everything else.
Yes, and from your practical experience, and anyone feel free to chime in here, but do you see a difference in the way you communicate with the public in general, regulators, customer, the staff, or would you have consistency prevail over everything else, or do you make differences depending on who you're talking to? How do you balance the need for consistency with the specific audience you're talking to in that context?
Yeah, and quite often it can be really difficult, right? When you've got regulators with really opposing kind of aims or goals with respect to their questions and the information that you need. So you'll naturally provide far more information if, for example, the FCA is talking about resilience a lot more and wanting to know when you're back up on your feet and what your workarounds are, and you haven't said any of that to the ICO. I don't think that's too much of an issue. And for example, you don't need to burden employees with technical details as to what's going on. So you really do have to understand who your target audience is. I guess you've just got to anticipate where their concerns are. If it's a regulator, what are they regulating? Personal data versus disruption to services, for example. And then employees, you just don't want them to speculate. So you want to give them enough information to be able to conduct their day job. And if they get inquiries, they don't start going off on a frolic of their own and speculating and talking outside the organization.
Yeah, interesting. Now, just moving on to collaboration with foreign law enforcement and regulatory bodies during an incident. Like Sean, how can companies navigate that? Like, what kind of advice can you give them?
I think a lot of it's interesting to incorporate some of the things that Nicola and Tim have referenced, but it really begins once again in preparation. This is all about instant response, and I found that every moment you spend preparing for it, the much better you are in responding to it. And like Nicola referenced earlier, it's important to map out the circumstances which that may evolve that ultimately provide obligation to notice to or collaborate with law enforcement or regulatory bodies. So really at the very outset, when you're not in the crisis mode, identify what those potential circumstances might be that cause that to happen. And then when we reference these playbooks, well, the playbook should actually incorporate the experiences one has had or the expectations that entity, that agency, or that entity may have in terms of how we notify them or collaborate with them. And in terms of Tim referenced, sometimes you've got conflicting expectations of different entities. Got to identify what those are and make sure we navigate that. And it's worth every minute we spend up front with a client. We have multiple sets of eyes when we draft the narrative to make sure it's objectively accurate. And that's the key here. It's, transparency is one thing, but being objectively accurate is a whole nother level. And then oftentimes we want to make sure that the client wants to do the right thing. And oftentimes they want to lean into sharing information that may not necessarily be accurate. They're speculating, they're hoping. And we want to do our best to walk them back from that and have them visualize actually having that town hall, if you will, with a C-suite of a major client, or talk with multiple government agencies and get a feel for what they're actually saying and what words might actually trigger a different response. And so literally, again, every moment that's spent either before an incident occurs or during the incident to make sure the narrative is objectively accurate is absolutely critical. And then, like I said before, we're also busy. Clients have a business model to run, and it's really difficult to find that discretionary time to reach out proactively. But to the extent that you could do anything like that and cause you to be perceived just a little different, maybe a bit more collaborative or cooperative, is going to benefit you in the long term as well.
Thank you. And Nicola, do you have anything to add to what Sean just said?
I think it's just important, fantastic response and covered most of the points I would make too. But just to note that, also know your insurance policy. There are some insurance policies, particularly like, for example, in France, where you have to have notified the police and you have to have engaged. It's not an option. You have to have filed a complaint in relation to certain incidents. So it's knowing that. I mean, one of the things we're always advising clients on is this balance between from a reputational point of view, wanting to be seen to be collaborating. It's great in comms to say we told the police because it very much puts it in this was an attack on us, this isn't our fault. But also knowing that actually engagement with law enforcement can do things like waiver privilege, depending on what you're sharing. So really important considerations. Will they ask questions that you can't answer? Will take resource from what you're under high stress. Your IT teams really need to focus on getting the business up and running. Are you able to manage like that full engagement with law enforcement, depending on, what kind of support they need or investigation they want? And some of that information you might be sharing might be quite sensitive, and you've got to think about it in terms of what you're saying to the regulators too. All those messages need to be very consistently given, and you don't want to be giving a different impression to the regulators than what you've kind of told law enforcement or what they're looking into. And they might then be doing their own investigation and come to different conclusions, which might not be helpful for you as an enterprise, post the event, if you're looking at litigation and, law enforcement might have taken a different view. So I definitely think it's important. I think it's important to think about it, particularly if it's in your insurance and you're relying on cyber insurance policies, and obviously that is vital. But it's also I don't overshare as well. It's just really being strategic around it.
Yeah, I mean the role of law enforcement authorities is I think an interesting one, and I think a lot of clients struggle with whether they should reach out to them or not, what are the pros and cons, whether they have to, if so how, when. And I think I really like I mean the points that you both made, but like one point which I think is really critical is when you have time to engage with them in advance of an incident, when there is one which require involvement of law enforcement authorities. If you did engage with them in the past, it's much easier because you know who you are talking to, you have established a relationship, you have the chance maybe to have a meeting with them, and they can be helpful. I mean, depending on the breach, or breach where it's slightly different, but there are situations where you do need help of law enforcement authorities as well. Moving on to the last topic, and we have 4 or 5 minutes left, just trying to look ahead and look at the future. The geopolitical landscape is evolving, and I think it's fair to say that the cyberspace is getting fragmented. Look at like what's going on in Asia, in Europe, in the States, and the like. What's the impact of that fragmentation on your global incident response plan? How can you prepare for that, Sean?
Yeah, and I think this is one of those things we just mentioned. Things are happening, and some of these things that are happening, whether it be regulatory actions, new legislation, the malicious exploits, some of these things are things we couldn't have imagined months ago, let alone a few years ago. And so I think it's critical that in the preparation phase, in order to handle that, prospectively, the corporations really need to, or organizations really need to identify the resources to broaden their view, to broaden the enterprise view, and broaden the enterprise awareness. And it may be, depending on the geopolitical developments, for example, enterprises may have to take a much more aggressive approach to information security, really identifying threat actor techniques, and procedures, the TTPs. Now, what I mean by that is that, the threat actor intelligence services are a lot out there, but quite frankly, those are something that's always been kind of discretionary, and maybe those with more discretionary spend. But right now, it may be much more critical to get a feel for those threat level services that organizations should participate in, and so they have a view as to what the trends and patterns are of malicious activity, and then how that comports with what's required of you from a regulatory perspective. Intelligent enterprises, I would expect to see, as part of what's going to happen down the road with regard to those types of services offered, more threat intelligence services, not just provided, but actually consumed by organizations to try to stay abreast of that. If you're not constantly learning, you're not just staying static, you're getting behind. You're developing vulnerabilities, perhaps not physical or technical vulnerabilities, but vulnerabilities in your own intelligence, which can come back to bite you big time. There's probably going to be it should be an increased placing of priority on risk-based decision-making, for instance, and that's oftentimes what we might recommend when we're looking at risk assessments. It starts out with that foundation. But the business leadership in this case really needs to be involved in that, buy off on that, make sure they're investing in it. And then I think executives really need to make more defensible, if they do this, we'll maybe make more defensible risk-informed choices that are more likely to help them navigate the organizations with resilience. From response to recovery, but it's really open up that visibility into what's taking place, so you're aware of it ahead of time, and you don't have to respond spontaneously.
Yeah, now looking at it from a legal and regulatory standpoint, Nicola, maybe you can tell us what you see as emerging trends. Like, if you take your crystal ball and look at the future, what do you see coming up soon?
Well, a lot more regulation in Europe, but I'm sure I don't need a crystal ball for that. I mean, in terms of what I'm sure pretty much all of our clients and contacts on tuning into this now will know that DORA, NIS2, we've obviously got supplemental kind of legislation too, like the Digital Networks Act, Cyber Resilience Act, other things, lots of things touching upon cyber operational resilience. And we're getting more in the UK. I think in terms of trends, and I'm very conscious that we haven't got long, but just in terms of trends, definitely a lot more management oversight. No longer possible to just delegate to your CISO, CIO. Boards need to be aware, need to know what's going on. Obviously NIS2 and DORA is bringing something in that's very unique and unusual in Europe, which is personal management responsibility, which something we've had in the UK with the senior managers regime in financial services. But something very, very different, for a lot of continental Europe. And then also another trend, which is regulation of a variety of industries. Under NIS2, under DORA, we're actually seeing regulation of technology companies, postal services, things that you wouldn't normally see, not your traditional financial services, energy, telecoms, etc. So that's a real shift in paradigm. And I think we're realizing now that operational resilience, cyber response, all of this is key to our day-to-day life because every company relies on technology. So I think just in terms of crystal ball, this is not something now that people can just put on their vendors or ignore. Everyone needs to be aware of that now. I'm sorry, I'm conscious of time, so
it's perfect timing. We're just ending right now. So thank you. I'd like to thank you, Nicola, Tim, and Sean for participating in the panel, and give the floor back to both.
Yes, thank you all so much. And Cedric, thank you for doing a great job moderating the panel. Really appreciate everybody's time and thoughts today. So we have one panel left. It's going to start in 5 minutes, called Ransomware in Europe, Best Practices and Pitfalls for Corporates and Other Organizations. So we will be right back.